I'm still disappointed in Elon Musk for making these statements. These were not appropriate statements. Somebody said his submarine wouldn't work. The appropriate response is, oh, yeah, I accept your challenge. I'll prove my submarine works. Or, you're wrong. You're a jerk for saying that, go shove my submarine up your butt. Those are appropriate responses, not you have inappropriate relationships with children.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
I guess it's not over the weekend, but last week, I guess December 6th, a jury decided that Elon Musk did not defame Vernon Unsworth by calling him the kind of person that goes to Thailand to spend inappropriate time with children. These are the phrases we have to say to try to avoid demonetization on YouTube these days, because heaven forbid we said the P word. It's just like instant demonetization and depromotion and all that. So we're, of course, not here to talk about that, but that's what he was called. That's what made it a defamatory statement, and arguably made it a defamatory statement per se. Now, the difference there is really, really important. A defamatory per se statement does not further need proof of damages, and a jury can find defamation based on the statement alone. So the P word in this case could be enough for a jury to find it to be defamatory. But there's varying definitions as to whether something that has no damage is defamatory, or whether you still need to prove actual damages. Let's take a quick look at defamation per se and defamation per quad, which are the two kinds of defamation, and this might help explain why a jury might have found the way that they did. And this is California, right? So California has a broad definition of per se defamation. It consists of anything that is damaging on its face without further explanation. Most per se cases occur when someone falsely accuses another person of having committed a crime, or being unfit to practice a person's trade. So committing a crime was this one. Name of plaintiff claims that defendant harmed him by making one or more of the statements. Here are the statements. And then to establish the claim, they must prove all of the following: that defendant made the statements to a person other than plaintiff, so we know that he tweeted it out; that this person reasonably understood the statements were about the plaintiff; that they reasonably understood the statements to mean grounds for that's there's defamation per se; and that the defendant failed to use reasonable care to determine the truth or falsity of the statements. If plaintiff has proved all of the above, then he is entitled to recover actual damages if he proves that the wrongful conduct was a substantial factor in causing harm, expenses, harm to reputation, and shame. So that's where I had an issue with this case. Not that the statement wasn't defamatory per se, but rather that I didn't see damage. And even in a California defamation per se case, you still need to show harm to property, business, trade, profession, expenses, harm to reputation, or shame. Now, expenses is not going to is going to need to be legally connected. So it's not, I think you defamed me, therefore my expenses are my legal bills. That could come into it if it was found to be defamatory as a compensation for the prevailing party or something, but not as part of the harm. The direct harm would have to have direct financial losses. I didn't think that Vernon Unsworth proved that he had any damages really whatsoever, although I wasn't there for the trial, so I don't know what he presented in his defense, or in his offense, what he presented in favor of actual damages.
What I heard was Musk explained to the court that his use of the word was a colloquialism from his time in South Africa, and that word using to describe somebody, it wasn't like anything ridiculously bad or something like that. Like, I don't really know the way that it was phrased since we don't have transcripts of the case, but something like, oh, that's just something you call somebody in South Africa, which doesn't make sense to me, but even taking that as being true, the issue that I have here is that there was an email that was sent to BuzzFeed by Elon Musk that had factual allegations in it. And whether or not Musk intended for that email to become private, it looks like, if you go back to the California per se requirements, it looks like it doesn't matter if it was going to go public or not. Like, he still made these allegations. Do you remember the allegations that I'm talking about?
Yeah.
Yeah, that sounds unequivocally like defamation. Do you agree with me on that?
Yeah, I do. I agree that that's all defamatory per se. I'm not the facts. The facts would be defamatory per quad. That's the other one. So that's when you prove defamation defamation by facts. My example I gave to Technical the other day, I think, was if I'm a dolphin trainer. If you just go and say Leonard French doesn't like dolphins and Leonard French has nothing to do with dolphins, there's probably no defamation there without someone proving more that like somehow that means something and there's damage. But if I'm a dolphin trainer, then saying Leonard French doesn't like dolphins might be saying that I can't perform my job, and that switches over to defamation per se. And I still think there needs to be some proving of actual damages, but there doesn't need to be that extra step of is it defamation? Calling someone of the P word, so someone who has inappropriate relationships with children, that would definitely be defamatory. I don't need to look further and say, well, do you work with children? Do you have children? Are you going to have children? Or are you around human beings that wouldn't want to socialize if they knew that wouldn't want to socialize with you if they knew that you had been called that word? You don't have to prove that. Like that's, but then you still have to show what your financial damage is. This is a discussion I got into with some lawyers on the lawyers subreddit, and they too have a bit of a disagreement over whether you need to prove another level of actual damage, or I think one is the causal level of damages, and then one is the financial compensation damages.
So the California per se statute that you were looking at, it didn't say you have to have damages before you can bring suit. It says that in order for somebody to be found of defamation, you need found for defamation, and to be for that to be adjudicated in a civil case, you need to prove that you were defamed and then prove that there were damages, right? And I'm pretty sure that this case ended with Musk being ruled as not having defamed Unsworth. Like, I think that was how this, because Musk walked out all high and mighty, like, haha, I was right. This is what happened. You know, that's not a bad word in South Africa. And it's like, but how in what world did he not defame Unsworth? And I know that you want to focus on the fact that there's no actual damages, but I think that the jury found that he didn't defame Unsworth.
Well, there's a section here that I didn't read called assumed damages. Even if plaintiff has not proved actual damages for harm to reputation or shame, mortification, or hurt feelings, the law assumes that he or she has suffered this harm. Without presenting evidence of damage, plaintiff is entitled to receive compensation for this assumed harm in whatever sum you believe is reasonable. You must award at least a nominal sum such as $1. So the jury could have awarded a nominal, could have found the defamation did occur and found a sum of $1 as sort of a exoneration of Elon Musk. Why was that not what happened? What was presented to the jury? Or is it possible that there's a little bit of celebrity blindness here? Elon Musk has reached a level of society and fame and popularity that he is famous. He's a celebrity. And maybe a jury is like, nah, Elon Musk didn't mean it. We know Elon Musk. He didn't mean it.
Yeah. So I have a few theories. That's my first theory, is that Musk is just too widely known to be sued. And that's definitely the one that makes me lose my faith in humanity. Like, if that's the case, then, well, okay, then I guess nobody gets sued if they're too famous.
Okay.
Like, that's kind of terrible, right?
So when you're trying to determine defamation, it's multiple factors. You have to determine, among other things, that the statement is intended as a statement of fact, and that it was about and concerning the person who's suing. And so Elon was arguing it's not a statement of fact. That word was not intended as a factual representation, but just as a slur insult. So that would be one basis to say this is not defamatory because it's not intended as a literal statement of fact. What the jury seems to have concluded based on jury interviews is that the tweet was not about and concerning the guy who sued. They said that it didn't mention it and there was not sufficient tie to say that Elon was talking about this guy in particular. Now, that's a question of fact, whether or not it did or did not. So the jury looked at the tweets, the jury heard the argument, and they, in their decision, unanimously said it doesn't concern them. So I'm happy to yield to their judgment. They looked at the evidence and said the tweet doesn't concern them. So, okay. So that's a reasonable basis to say it's not defamatory.
Yeah, and I agree with being behind the jury, but I do want to point out that there is such a thing. So we've all heard of jury nullification, right? That's when a jury will sort of find someone not guilty, even if they are clearly guilty. Is this a case of jury nullification, even though there's clear evidence of a defamatory statement? Does that necessarily, translate into a judgment when a jury doesn't have to give reasons?
My reason to assume not is because it was according to the record, apparently about 20 minutes of deliberation. So I don't know that you necessarily would reach that conclusion in that kind of time frame. Be like, well, we really know he's guilty, but we're going to look the other way.
I think you can reach that conclusion that you're going to look the other way pretty quick. At the same time, isn't there also the opposite of jury nullification? There's a judgment notwithstanding the verdict.
Yeah.
And is that something that I might expect the Vernon Unsworth team to be considering, either a motion for something or maybe a judgment notwithstanding the verdict, to say, hey, there is overwhelming evidence that this statement is defamatory, that it did affect him emotionally, and that there's some kind of damage here, even if it's just nominal damages of $1.
I don't know if you can do a JNOV the other way. I mean, you can do a JNOV in favor of the defense, but I don't know if you can do a JNOV in favor of the plaintiff.
Or something like that. Yeah. Yeah, and in a civil defamation case, I don't think you can do something like that either. So
that was my third theory, was the nullification thing.
Yeah, I think it's jury. I'm firmly on the side of this is jury nullification. Now, if they had found, I think the proper thing to do would be to find the statement to be defamatory and then award nominal damages of $1 and saying that there's not really any damage here, rather than saying that the statement itself wasn't defamatory, when case law, basically lots and lots of case law, says that calling someone that is automatically defamatory. There really shouldn't be any jury deliberation on whether it is defamatory or not. It should be on whether the damages are $1 or whether damages are $190 million.
And I want to also go back to the fame of Elon Musk as a factor, because I don't know whether or not the statement as fact is viewed subjectively or objectively. Is it the question that it's viewed from the point of view of a reasonable person, or what Elon actually intended? Because if you're saying, well, is this intended as a statement of fact based on what Elon himself actually intended, not on how it would be perceived, but based on what he intended, then considering Elon's character would be totally relevant in that context, because you're trying to determine what he actually subjectively meant. And so looking and well, we know Elon and the way he acts would be perfectly valid consideration going to Elon's subjective intent. It's yeah, Elon says stuff all the time. He didn't really mean this. That would be a perfectly reasonable conclusion if you're viewing it subjectively.
So my second theory was something else. So my second theory was that for some reason, the judge made jury instructions that included the fact that that email wouldn't be included in their documents in their package. So for some reason, that email was ruled out as evidence. That was one of my theories. And somehow they ruled only on the tweet,
okay,
and not on the email. But I can't think of a reason why the judge would do that. Why would the judge? This email is clearly defamatory. Why would the judge discard it as evidence?
Yeah, I think it's a case of celebrity blindness and jury nullification. Not just because I didn't get my way or something. I didn't really have a dog in the fight. I personally am on the side, and professionally I'm on the side, that calling someone having inappropriate relationships with children and calling them the P word, you don't need to go further to say, oh, well, does he mean it or not? Or, that's defamation per quad, and that's not what was at issue here. I kind of feel like the jury ruled on defamation per quad when the standard was really defamation per se. But I'm sure there will be further analyses, and Unsworth's attorney, who is L. Lynn Wood, who, while I don't remember what L. Lynn Wood's pedigree is, I remember him being a very prestigious and very accomplished attorney. He said that they will take a few days to make the decision about appealing the verdict. I expect them to appeal. I don't see how calling someone that is not automatically defamatory. I can hear arguments all day that the damages were nominal or little, $1 to a few $1,000s, maybe to a $50,000 something, but 190 was just off the charts unnecessary for our damages request. I personally think a $50,000 damages request would have been perfectly reasonable, but and maybe the jury saw the fight on that end as being greedy and nullified it there too. So I don't know. I don't know any further than that.
I just want to say that I love Elon Musk. I love what he's doing, but I really did think that this was defamatory, and I'm a little bit outraged that this happened. Like that the jury.
Yeah, I'm still disappointed in Elon Musk for making these statements. These were not appropriate statements. Somebody said his submarine wouldn't work. The appropriate response is, oh yeah, I accept your challenge. I'll prove my submarine works. Or, you're wrong. You're a jerk for saying that, go shove my submarine up your butt. Those are appropriate responses, not you have inappropriate relationships with children. That is.
I do believe that there was at least one attorney on the jury. And
yeah, that's right, too.
My understanding is
baffles
that
me.
it's a fairly notable attorney, and I'm just going to assume that as an officer of the court, that jury nullification is less likely. I mean, obviously, he's a human being and subject to human impulses, but
Yeah.
I'm going to assume he took his role relatively seriously. I'm going to assume that in 20 minutes he didn't say, yeah, well, whatever. I'm going to assume that he reasonably came to the conclusion that the standard wasn't met. So that's my bias.
Okay, but I've also met some opinionated attorneys, so I'd have to figure out who it is, and I'd want to research them and decide for myself whether they used bias, whether they were biased inappropriately in other parts of their life, or whether they seem to have that under control. If it turns out that it's an attorney who was a former judge and they're decorated and they've never had any discipline, yeah, I'm totally on your side. Or something even towards that spectrum. I don't mean that it has to be that good.
I'm gonna rely on my confidence in the system and assume that the result was as it should be, for the best.
Okay. Maybe you trust a little bit more than I do.
Well, we kind of have to. He's gonna appeal and he's gonna make his arguments in the appeal, but for all intents and purposes, for now, that's the judgment.
He might not appeal. Here's the only reason I think he might not appeal. If he realizes that he did not present a great damages argument at the lower court, he's not going to be able to present a new damages argument again. So he's not. I don't think he's going to get a brand new trial or something like that, and be able to present brand new evidence or whatever. So I think that if they don't appeal, it's because they realize that even if they win, they're only going to get nominal damages. The disagreement would be the finding of fact, but there is such a thing as a finding of fact that flies in the face of overwhelming evidence. And so an appeals court might say, well, it's a matter of law, not fact, that calling someone that name is defamatory per se. So it should not have been presented to the jury as a jury question on whether it's defamatory per se. It should have been presented to a question as what are the damages? How much does Elon Musk owe? That's how I see it. I think it was a foregone conclusion that it was defamation per se. But I'll let L. Lynn Wood and Vernon Unsworth figure out what they're going to do next. And if they don't appeal it, that's probably why they just realized it wasn't going to be worth it. So let us know what you think in the comments below. How do you think the jury should have decided? So that's our show. Thank you for joining me. I am Leonard French, your favorite copyright attorney. Remember, this is a community-supported legal education and legal news and stories channel. So you can help us by liking the video, by subscribing and clicking the bell if you want to, and by supporting us on patreon.com/ljfrench and sponsors.com/law. Those are our financial support platforms. If you would like to subscribe, you can subscribe on Twitch to our live shows on Sunday, and then usually there's one on Wednesday or Thursday that we produce these videos. And you can, of course, subscribe to us on YouTube. We also sell merch through a Teespring store that we will be expanding very shortly once I get to my final destination. So thank you very much for joining me. I am Leonard French, your favorite copyright attorney. I will see you in the videos that drop. I love you all. Bye.